Uh, Welcome, everyone. This is the House Ethics Panel meeting on Wednesday, January 5th, 2021. We have two issues that we will discuss in public, which deals with the training that will be conducted on Friday, the January 7th, before the full House. And we will review the report that the House Ethics Panel puts out each year to the entire House. Then we will go off air and discuss a complaint that we received consistent with our procedures, which require complaints be reviewed on a confidential basis. So Betsy Ann, would you like to pull up the training?
Sure thing. One moment while I pull up share screen. Can you see that okay?
Yes.
Yes.
Okay. One moment while I maximize. Sorry. Way too many windows open. Thanks. All right. So this is a draft presentation that Michael and I put together, potentially that the panel could use for the training that is scheduled for this coming Friday after House floor. It would cover several topics in regard to this committee's jurisdiction, and Michael and I, however you want to approach it, Mr. Chair, Michael and I can walk through some of what we had planned for this training.
Sure. Why don't you do that, Betsy Ann?
Okay. So this would be held remotely since the House is now operating remotely. And what the two of us were thinking is that the chair could start out by giving an introduction of the panel and introducing the panel members and the staff, and then provide an overview of the training topics, which are listed here. And then go into, then Michael and I, if that would work, we could take over and walk through the slides of the training. And one of the things that we wanted to flag at the beginning is, well, how you wanted to handle any member questions that might come up. And we were thinking, I think both of us were thinking that that would be something that perhaps the panel chair could address at the beginning for how you wanted the format of the meeting to go and to whom questions should be addressed.
I do think there's some natural breaks in the presentation. I anticipate that we will probably get questions around Rule 75. So I think that would be a good point to stop after we finish the section on Rule 75 to see if there are any questions with respect to that, and then go into the financial disclosure and lobbying requirements in the second section. And then again, which is basically, then take questions again, and then finally our procedures, and just see if there's any questions there. Does that make sense to everyone?
Yes.
Yes.
I mean, I don't think there'll be a lot of questions about the latter two topics, but I do think a lot of people will have questions about Rule 75.
Sounds good. And we'll just note now that this is very much a draft training. So this is presented to you all as panel members, and you can give us feedback on any of the provisions that you think should be revised or anything that you think that we should, the format should be changed in any way. But Michael and I got together and we have a tentative plan for how we would handle. We would essentially be going back and forth and handling slides. So we would just start with an introduction, teeing it up to first talk about Vermont Constitution's principles of representative government.
And then I would talk about the Common Benefits Clause and how the government is for the benefit of all people and not for the advantage of just some. And that includes legislators, and all citizens have the same benefits and are protections afforded by state government.
That is consistent with Chapter 2, Section 12, which is a prohibition on fees for advocating bills that applies to legislators. This provision, I'm not aware of any case law interpreting it, but we do have some background on some of the terms that are provided in here, and we can just talk about some of the meaning of the terms and also our current interpretation of it.
And then I'll talk about the legislators' oaths of office under Chapter 2, Section 16 and 17, how they are the foundational components of the legislative ethics, and how they require legislators to basically act in a way that does not appear to you injurious to the people, and to conduct yourself as faithful, honest representatives and guardians of the people. We can go into a little bit more detail during the training as well.
And after you take that oath, you use it in part to judge member qualifications and, if necessary, expel members. And we can talk about here our one main case that we have in Vermont from the Vermont Supreme Court, the Brady v. Dean case, that interpreted the judging of qualifications to at least encompass the authority to determine whether a member should be disqualified from voting on a question due to a conflict of interest.
Then we'll transition into specific House rules, Masons, and statutory ethics provisions that will apply to House members underneath the ethics panel and generally underneath the authority of the House.
And going back to the Brady v. Dean case, which specifically mentioned House Rule 75, that's the House's rule that is in regard to judging whether a member has a conflict of interest. The House Rule 75 provides that members shall not be permitted to vote upon a question in which they are immediately or directly interested. And we have Mason's provisions that supplement that. The House adopted House Rule 88 to incorporate Masons to supplement any of the rules that are not specifically provided in the actual House rules. And so Mason's Section 522 helps supplement House Rule 75, and it's provided there in text. And then Masons, in turn, is a body of parliamentary law that's based on precedents from judicial case law, as well as challenges in legislative chambers. And so it is based in part on what's called Cushing's legislative assemblies. So that Mason's provision, it has precedent cited for it from Cushing's. And so some of the Cushing's provisions are cited here in regard to what constitutes a direct personal or pecuniary interest.
And specifically with regard to the direct interest and the pecuniary interest, it's belonging to a separate description of individuals, and it's not an interest that belongs to members of the public as a whole or to classes of people as a whole or arising out of general state policy. It has to be direct and not belonging to citizens other than yourself or classes other than yourself. I was going to discuss the one example that I know of where it was clearly a direct pecuniary interest. It was a legislator who was voting on salaries of state employees, and there was a class of state employees where there were only 2 members in that class, and one of the members was the legislator's spouse, and the legislator said, I'd basically be voting on my direct household income, and it was a direct pecuniary interest, and she claimed Rule 75, and that's really the only direct pecuniary interest I've seen in almost 20 years.
That's a good example.
So with that idea that House Rule 75 is really when it's in regard to a legislator directly, and not when it's something of a general public interest. We have discussed before that House Rule 75 has generally been interpreted so that if a vote would affect both a legislator and a larger group of people, the legislator is not required to recuse themselves because the vote is not of immediate or direct interest under Rule 75. But we did have language in here for your review. Tell us if you would like to keep is a best practice, and we would cite the Buckley v. Vallejo case.
Right. I think Betsy Ann,
Sunlight. Oh, pardon. You want me to stop? You don't want me to go through the details?
no, you froze. I
Oh,
think
I'm sorry.
you froze to me.
Okay, I'll start over. We were just going to quote the Buckley v. Vallejo
Okay.
quote about publicity being a remedy for social diseases, that sunlight's the best of disinfectants, electric light, the most efficient police officer. And language currently in here providing that members are encouraged to disclose before a vote on a question what impact the vote may have on them if they will vote on the question as a matter of public interest, if that's the decision they reach. I did want some feedback from the panel on whether you agree with those statements.
I agree with them, but I was questioning our practice of what happens when people do claim Rule 75. And I think the last time that happened was when we had a bill that was dealing with military pensions. And I believe a number of people did not vote and claimed Rule 75 because they had, though I don't know this for a fact, had military pensions. And is that the appropriate process?
So, and I see Representative Chena has joined us. We are on live here online. Representative Chena, FYI. To answer your question, Mr. Chair, I don't think that was a Rule 75 actually, because it wasn't immediate or directly immediate or direct interest of those members. Our House rules say that members shall not vote on a question of immediate or direct interest, but otherwise members need to vote. So really, if they don't meet the provisions of House Rule 75, they should be voting if they are there when the question is presented. So
if that is the case, would the appropriate procedure be to call a point of order?
That is a good question. I haven't seen that happen in practice. We have the language for what to do to challenge a member because other members think they have a immediate or direct interest. I haven't seen it done in practice that someone challenged their not voting, but I think under the rules, because you are supposed to vote unless you have one, it's at least possible to ask that a member vote or to at least explain why they didn't vote.
I've never seen it either, and I think largely because when it gets to that point, the speaker usually asks for a recess and tries to work it out at the podium or elsewhere. I don't think it's ever gotten to the point where a member had to challenge the assertion of Rule 75.
Yeah, but on that vote, I think there was at least a couple of members that claimed Rule 75, which, you know, given that it has, usually it's a unique to your unique interest, financial interest, would call into question people using Rule 75 not to vote. Right?
Yes. We have some other citations that we could provide in here if you wanted to, that cite the House rules that require members to vote if they don't have an immediate or direct interest. The other provisions of the House rules that say that when the question, if the members in the chamber, when the question is stated, the member should be voting. Would you like us to include those references to those rules here?
Yes, please. Okay.
But yeah, maybe we should also include a statement that they are a member that is questioning Rule 75's applicability to them should consult with you so that you can advise them on whether or not their interest is direct or not.
Okay. How about the panel though, too, or a panel member?
Yeah.
I think that's a very good point, Michael. Kimberly, you have your hand raised. I apologize for not calling on you.
No. That's exactly where I was kind of getting into the actual, how would it work on the floor as this is unfolding? And Michael made the point that there would potentially be a recess and a conference with the speaker, but in terms of maintaining the flow, I like the idea of stressing that it's kind of incumbent on the member for him or her to take responsibility to try to sort that either through conferring with the clerk or such, rather than stopping the entire house at that point. And just to sort of point out the operational aspects of it as well as the legal background.
I would think procedurally, it would probably be similar to, I believe, what is the next, no, one of the, here we go. The Masons 231-6 about raising a point of order. This is about questioning the right of a member to vote because of a personal or pecuniary interest. But I would think the reverse, it seems logical that the reverse would also be true. If a member in a roll call votes to abstain by Rule 75, and there was a question about whether Rule 75 actually applied, my gut response now would be to think that the same procedure would be used, that perhaps that member's abstention from voting could be challenged after the vote has been recorded, but before the result is announced. And at that point, potentially we could take a recess. It would be cleaner if, and the purpose of this training is to give members this background so we don't reach that point. And if members had questions, they could consult with panel members, or I'm happy to consult with them on the floor as well about the scope of Rule 75.
So given it's likely that somebody from the ethics panel would call that point of order, the most appropriate time, especially if we're doing a roll call, would be right at the end of the roll call or right after the vote.
It would be right after let's see. We can't interrupt a roll call. So I think it's after the end of all of the roll call. And at that time, the clerk's staff are calculating the votes. The vote does not become official until the speaker announces it. So I think it would be during the time that the votes are being calculated is how I think that would work, because I don't think members should be interrupting a roll call.
Okay. Thank you.
Thank you.
So after the conflicts of interest discussion, I'm going to talk about disclosures, and I'll first note why disclosures are an ethical issue. It's because they provide that transparency that allows the public and the House as a whole to determine whether or not there are conflicts of interest. And there are disclosure requirements under statute, under 17 VSA 2414, and under House Rule 14A. I won't go through them now, but I will go through them on Friday.
Good.
Now,
I had a question about this slide. Go ahead.
Okay.
And it was just why this is here after the disclosure section.
So I was going to pick up because the purpose of disclosures is to help provide transparency on potential conflicts that a member might have. So I think the disclosures, you can tell us if you think the order should be rearranged, but I guess in the way I was thinking of it is that disclosures are a way of other legislators determining whether another member does have a conflict or potentially has one. And so those might assist the chamber in determining whether a member has a conflict of interest. But if you think it's more appropriate to put this directly after the Rule 75 language, be happy to move it there.
What do others think? I mean, I was just confused by just the.
Yeah, I think moving it forward because, again, I'm a little bit thinking about operational terms still. So the idea that people would be shuffling through all the disclosures at that point, I don't know if that's realistic, but I take your point, Betsy Ann, that is the platform from which this springs and could be used, for making your determination.
All right, that makes sense. Yeah, we can move that. So this is currently slide 14. We can move it to then come before the disclosures. Great, I will do that. Sounds good. All right, so it'll go the conflicts, then challenge, then disclosures. Thank
Okay.
you.
Good.
And then from disclosures, we then go on to interactions with lobbying entities. I'll first define what a lobbying entity is as the registered lobbyists, lobbying firms, and lobbyist employers, meaning those persons that engage a lobbyist for their services. Talk about how legislators are prohibited from soliciting gifts, how they're also prohibited from soliciting or receiving campaign contributions during the biennium until adjournment sine die. Talk about limitations on lobbying entities, how they have to disclose contracts over $100 a year or direct business relationships, how they are prohibited from giving legislators monetary gifts other than campaign contributions, and how they're prohibited from lobbying for 1 year after leaving office.
So then we would go into saying, all right, we would just talk to you about specific provisions that House members need to comply with that are bright line disclosure requirements and prohibitions on or regulation of your interaction with lobbying entities. But now we're going to get into the constitutional aspect of each chamber needing to make choices that are not specifically addressed. And it is judging members' qualifications and analyzing their conduct to determine whether any discipline is necessary as a measure of upholding chamber integrity.
So then I will talk about legislative discipline, and I'm first going to start off with a discussion of the speech and debate clause under Chapter 1, Article 14, because I think some members believe that totally immunizes them from any disciplinary action. But that clause really only applies to any other prosecution or action or complaint in any other court or place whatsoever. It's not about the inherent authority that the General Assembly has to discipline its own members. And when you look at Mason's 561-1 and 2, it clearly says that the body has that right to discipline a member as it deems appropriate, including reprimand, censure, or expulsion. And the Supreme Court of the United States has supported that in its precedent on Congress. It has an inherent power to punish its members for disorderly behavior and in extreme cases to expel. And it's necessary in order to uphold the reputation and integrity of the body so that members aren't free to act however they want within the legislative sphere.
Kimberly, do you have another question?
Yes, my question is going back to the lobbying entities. I've seen before in the lobbying book that there's a photograph and then there's the various clients that are listed, or, you know, the organization that someone is advocating for. But there was a mention of relationships, and where would members find that? I can't remember how it was worded. What does it say here? Or direct business relationships. Would that be part of financial disclosure? Or where would one find that if they were interested?
It is part of the disclosure form. Betsy Ann, where would they find that?
So those are
declare?
posted. Those are posted on the Secretary of State's website. The Secretary of State is the entity charged with regulating lobbyist disclosures. And so all lobbying entities are required to file these disclosures. And so if they did have a direct business relationship with a legislator, they're posted on the Secretary of State's website.
Great, thank you.
All right, so Michael talked to you about, we have this not only in Masons and in US Supreme Court, even our own Second Circuit, that the legislative discipline is an inherent legislative authority for the purpose of self-protection. This is not a novel concept. This has been in case law for across the nation for a long time. We have from the California Supreme Court stating that even in the absence of an express provision conferring the power, every legislative body has the power to, the implied power to expel a member for any cause that it deems sufficient. The Massachusetts Supreme Court says that expulsion is a necessary and incidental power to enable a chamber to perform its high functions, and it's necessary to the safety of the state. Pennsylvania Supreme Court said when chamber expels a member, it is seeking to punish the member for misconduct and to protect the integrity of the legislative process. So the message here in this case law is that it's up to the chamber to determine what is the conduct that is appropriate for its members. The chamber is in charge of regulating its members and making that decision.
But that legislative discipline authority is not unfettered. You still have your constitutional rights, and a court will look to see if legislative discipline violates your First Amendment rights or due process or other constitutional rights. If the court finds that your constitutional rights are not violated, the courts generally and almost exclusively do not weigh in on the boundaries of legislative discipline. There's really no known case law that places limits on the type of legislative conduct that might be discipline. And that's consistent with what's called the political question doctrine. Likely will be touched on before we get to this slide, but that's the doctrine that prevents judicial review of matters that lie within the authority of other branches when there is a textually demonstrable constitutional commitment of authority solely to one branch. And as we referenced in previous slides, the General Assembly, the House, has the authority to judge the qualifications and criteria of its members and the authority to adopt rules for the regulation and operation of the body. So those are textually demonstrable commitments of authority, and the courts do not have authority to weigh in on how they are implemented.
For example, in the 1905 California Supreme Court case, the court there said there's no duty or power of the judicial branch to try to control legislative disciplinary authority. These are functions that are committed to the legislative department, and any attempt by a court to try to direct or control the legislature in that exercise of that disciplinary authority would be an attempt to exercise legislative functions, which under separation of powers, it's expressly forbidden to do. And what the court said there is tying back to the oath that Michael talked about earlier, was that the oath of each individual legislator and their duty to act conscientiously for the general good is really the only safeguard to their fellow members against an unjust and causeless expulsion in that case. And that's repeated in Mason's. That case exactly is a basis for Mason section 562, which reiterates the same thing about the importance of the oath and that being the safeguard against unjust legislative discipline. Included also just this case from Massachusetts from 1855 that essentially was demonstrating in extreme hypothetical examples the scope of legislative disciplinary authority. The court there said a member can be physically, mentally, or morally wholly unfit, afflicted with a contagious disease, insane, noisy, violent, or disorderly, or in the habit of using profane, obscene, and abusive language. It's necessary to put it to an extreme case to test the principle, because if the power exists, the House necessarily is the sole judge of its exigency and may justify and require its exercise. And the court said any attempt by the court to express or define that authority would impair it rather than strengthen it.
And then we'll talk about some examples of legislative discipline in Vermont. Really the most modern example is from 2016 when the Vermont Senate suspended a senator for sexual assault related charges till all criminal proceedings pending against him were dismissed. The charges were not adjudicated by the judicial branch, and the senator did not resign and remained suspended through the remainder of the biennium. Then we'll turn to Congress. A couple of examples there, how the U.S. House censured a member for failing to report income on a federal tax returns. And basically, he was censured and required to pay restitution to the appropriate taxing authorities and provide proof of payments to the House Committee on Standards of Official Conduct. I'm also going to reference I won't use his name, but it's the William Jefferson case, the Louisiana congressman who was caught taking $100,000 in bribes from FBI, and how he subsequently would not resign. He was removed from his congressional committees. And then during the criminal prosecution, he claimed speech and debate immunity, and the lower court granted it. The lower court said, yes, the FBI shouldn't have conducted the investigation, and basically infringed on his constitutional rights as a legislator. And then the circuit court said, no, speech and debate immunity does not extend to criminal or political activity that is not a legislative act. So they said, no, speech and debate is not a defense to bribery, is not a defense to the legislative discipline that was imposed on him.
And Michael, the 2016 Senate case is like the only recent case of discipline in the General Assembly, correct?
Yeah, I think the other one was pre-1900. Others were pre-1900.
Right. That's what I remember.
Going back to that issue of separation of powers, this California case from 1905 is a great example of the role of the two branches, legislative versus judicial. In this case, the California Senate expelled members on the basis of bribery, but they weren't convicted of that crime. It was the California Senate judging that their own members committed bribery, not the statutory crime of bribery. They cannot convict members of the statutory crime of bribery, but the chamber judged that its members did commit bribery and expelled them for it. But the members challenged their expulsion because they said, in part, we weren't convicted of that crime when you expelled us from office. And the court there said, it's obvious that the criminal bribery statute is not intended to have any effect whatever upon the power to expel the members of the legislature. They're two different things. They're made for different objects and purposes. Power to expel is given to a chamber to protect itself against participation in proceedings by persons it judges unworthy to be members of thereof, and affects only their rights to continue act as legislators. On the other hand, bribery defines a certain crime, and it prescribes the effect of a judgment of conviction on a person who's convicted and found guilty of that crime. A resolution expelling a member by a chamber, whether bribery or some other offense or improper conduct, is not the equivalent of a conviction of the person of the crime set forth in the charges against him. And that's reflected in the Senate action that the Vermont Senate took. It was based on the criminal charges, but it didn't have an impact. The two branches did not have an impact on each other by their actions.
So then I'll talk about examples of how the legislature's authority to discipline is not limited to the current biennium. You'll see a South Dakota example of where the legislature disciplined for behavior that occurred in a prior biennium. And the courts basically said, well, the legislature has that inherent authority to manage its own members and carry out its constitutionally mandated duties, and that the court had no authority to stop the disciplinary process. Similarly, in New York, there was an instance where a member was elected but not yet sworn in, and was found to have engaged in domestic battery. So before he took office, the legislature moved to basically expel him, and the court again said that the legislature has an extremely broad standard for decisions about the fitness of their members in order to protect the reputation and dignity of the body as a whole.
So we provided those examples as just examples of what other state legislative chambers have had to deal with their members and how they have handled member misconduct. And so that's what the House Ethics Panel does when it analyzes complaints. It has to make these types of determinations if it were presented with conduct like some of what was at issue in the other legislative chambers. So now what we'll review is the panel itself and its procedure. We've got the panel set forth in rule, and then it adopts procedures. So we can review those with you.
Then I go through House Rule 90B. I don't have to go through all the requirements in 90B right now. You've seen it all before.
Yep.
And then I can talk about the state panel's relation to the State Ethics Commission. Its duty is set forth in 3 VSA 1221. In recognition of each chamber's constitutional authority to regulate its members, the statute currently provides that if the commission receives a complaint about a legislator, the commission refers to the complaint to the legislator's ethics panel, in this case for a House member, the House Ethics Panel, and the commission requests a report back regarding the final disposition of the complaint. Although, again, in light of separation of powers, if the complaint also alleges that the legislator committed a crime, the commission would also refer the complaint to the AG and the state's attorney of jurisdiction. And then language in the commission statute provides that complaints and related documents in the custody of the commission are confidential and exempt under the Public Records Act.
So then I'll go through the panel procedure. I'll note that the panel is likely to propose some changes to the procedure, but they have not been adopted yet. So this is the current standard about the complaints must be in writing. And I will note that the current procedure is for actions that took place during the current biennium. So the panel's authority is limited to the current biennium, but the General Assembly's authority, the House's authority, is broader than that. So that is something to keep in mind, that if there is behavior that predated the current biennium, the panel may be able to refer that to the Speaker and the Rules Committee to take further action.
Okay. Huh. I understand.
Then I could review if it went to an investigation phase. We can just talk about what that would look like and the potential outcomes.
Look,
Oops, pardon.
there's a typo in one of these slides.
Oh no.
I'm just, it's one of the overview of panel procedures continued. Where's it talk about pattern of conduct?
That would be for closures.
It's
Oh darn, I know where that is. Oh, it should be under potential outcomes, this first bullet point here.
oh, there it is. It's in the first bullet. Pattern. It says patterns instead of pattern of unethical behavior.
Ah, okay, thank you, thank you. Noted. Good eye. Good eye. All right, I will make that change.
Oh, so then I talk about the hearings and the process to be used, the ability to call witnesses, to have counsel, that the standard is not technical rules of evidence, but hearsay can't be used, and that the standard is clear and convincing evidence, which means highly and substantially more likely to be true than untrue. And then the findings, if their panel finds a violation did not occur, it dismisses. Dismissal is confidential. And if they find that it did occur, they introduce for the House's consideration a House resolution containing the evidence presented, the panel's findings, and its recommendations for disciplinary action.
And then finally, I will talk about confidentiality and maintenance of records. Except for that House resolution that could be introduced for the full body to consider whether to discipline a member, panel members and staff are required to keep confidential any information received and records produced or acquired in accordance with the procedure. And all of those records are not subject to the Public Records Act. Panel staff are required to maintain all records associated with handling an ethical complaint. And if it's the situation where the State Ethics Commission referred a complaint to the panel and requested the report back on the final disposition, the procedure language states that so long as statute still requires the commission to keep confidential the complaints that they receive, the panel may provide to the commission notice of the final disposition of a complaint that it referred to the panel.
And then we hit the concluding slide and say thank you. House members are encouraged to reach out to panel members with any questions regarding legislative ethics.
And as the House's official ethics resource, the panel welcomes any member requests for ethical advice.
And we should emphasize that because we'd much prefer to answer a question than having to deal with a complaint.
Here, here.
Well said.
Great. Any feedback? Thank you for your careful review on that. And we have a few changes that I noted along the way. Are there any other changes you'd like to see at this point, or?
No, I thought that was great. Very well done. I think it'll hopefully help members understand their ethics responsibilities.
All right. We went through it quickly today. I think we'll have about an hour, I believe, that it's scheduled for. So we'll be able to get into more detail and elaborate a bit more, but we'll keep an eye on the time because I think
so that will be after House floor on Friday.
Correct.
Yeah.
Correct.
And it's mandatory.
I believe so. Yes, that's my understanding.
Oh, no, I mean, it's important that everybody understand the rules.
Yes, I'll reiterate it too in the email I send to members.
Okay, thank you.
Thank you. Great. Any other feedback? We can get into the draft. If not, the draft panel report.
Yep.
Okay. I will pull that up. Would you like me to share screen here?
Sure.
Okay.
This shouldn't take too long, I don't think.
Should not be long. Okay, so the panel is required to submit an annual report. We just, again, are in this situation where we were in person, now we're back remote again. So we can submit this, you can submit this as soon as you are able to approve this with any revisions you'd like. We've drafted this now as the initial draft, set it up based on some of your prior annual drafts. This language says that pursuant to your House rule that requires your annual report, the panel is reporting that in the year 2021, the panel received 4 complaints. It closed 3 of them because pursuant to section 3A of your procedure, the panel determined that there were no reasonable grounds to believe that an ethical violation occurred and that the 4th complaint is currently pending. Also, this draft would say that in the year 21, panel ensured that all House members submitted the following: your required the disclosure form prepared by the State Ethics Commission that was required of all legislative candidates, that was required to be submitted along with the candidate consent. And there's a footnote here directing people to where members of the public can find where those are on the Secretary of State website. For all members, their signed oath of office that's required to be submitted to the House Clerk's office. And then for all members, their disclosure required by House Rule 14A with the footnote indicating where those can be found online on the House Overview webpage. And then it ends with, in the year 21, panel members reporting receiving 3 House members' requests for ethical advice. That's my understanding of the number, but I just flagged that in case there were any more that I was not aware of.
So that's based on my reporting. So if anybody else received an inquiry, raise your hand or let Betsy Ann know. Okay, I think we're set then. So do we need to take a vote on approving that or?
Yes.
Okay. Can I have a motion to approve the House Ethics Panel report?
So move.
All right. All in favor?
Aye.
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 Okay. So at this point, Betsy Ann, we are going consistent with our ethics procedures. We have a complaint to discuss that must be done on a confidential basis. So could you